Working in the U.S. illegally is a reason why you cannot get a green card in many situations. If you are married to a permanent resident, if you have worked illegally but are being sponsored by a permanent resident, then your illegal work activity would eventually lead to the denial of your adjustment of status application if you applied for a green card in the United States. Instead, you would have to consular process or leave the U.S. to interview and obtain your green card abroad if you worked in the United States illegally. You should always consult with a competent immigration attorney about the facts of your case, because when you leave the United States, even if you're married to a permanent resident, depending on how long you've been in the United States without valid status, you could trigger an unlawful presence bar. Further, working illegally brings up other questions that you may encounter at a consulate interview as to whether you claim to be a U.S. citizen to get that illegal job, which could lead to a lifetime bar of any immigration benefit. Immigration attorneys refer to this as the false claim to U.S. citizenship status, especially those made after September 1996, to be the ultimate death knell for immigration. There is no waiver available for a false claim after that date. Many people mistakenly think that they have automatically claimed to be a U.S. citizen because they used a fake Social Security card or used someone else's Social Security number. This is not true, but it does open questions as to how you got the Social Security number to begin with. But there are many people who are not U.S. citizens who have lawfully have Social Security numbers. So again, it is wise to talk to an immigration attorney about the particular facts of your case before making any immigration decision. The situation, however, changes if you are married to a U.S. citizen. When you're married to a U.S. citizen and the U.S. citizen spouse is sponsoring you for a green card, unlawful work, as long as there's not a false claim to U.S. citizenship status and there's no misrepresentation to immigration, can be waived and forgiven. Basically, the unlawful work or illegal work won't be held against you when applying for the adjustment of status process for a green card in the United States. If you are the beneficiary of an immigrant visa petition by an employer, but the immigrant is also married to a U.S. citizen, but the U.S. citizen is not the one who is filing for the spouse's green card, the immigrant would still be able to adjust their status inside the United States without having to consular process. What's most important to show is that the immigrant is an immediate relative or married to a U.S. citizen to avoid an adjustment of status denial based on illegal employment. And in immigration law, there are unique exceptions to many of these hard and fast rules. So always consulting an immigration attorney to see if there's an exception for your facts is a very good idea. There may be very rare or minute exceptions that could apply to you or save your petition, even if you worked illegally. I am an expert in complex family-based immigration cases and have a 98% approval rate for the past 12 years. I am a nationally published immigration author and frequent public speaker on immigration topics. I regularly train other immigration lawyers on complicated marriage and family immigration cases for the American Immigration Lawyers Association, Federal Bar Association, and National Legal Education Providers. I represent clients all over the U.S., traveling to immigration interviews and deportation proceedings. Visit our website, humanrightsattorney.com, for more in-depth information and articles on complex family immigration issues.